of guilt against the defendant. This time, it is in relation to the defendant choosing not to volunteer information when he goes to court. So, there's a trial in progress. The defendant would be expected to take the stand. The defendant would be expected to subject himself to cross-examination. What happens if the defendant chooses to not take the stand? What happens if the defendant chooses to not volunteer any information at all? Is it possible that on account of his silence, the judge may direct the jury in the way of drawing an adverse inference of guilt against the defendant based on his silence at the trial? The answer is yes, he can. Section 35 of the Act allows the judge to direct the jury to draw an adverse inference of guilt against the defendant based on his silence at the trial, at the court. So this is not connected to the interview. Silence at the interview and a belated attempt to supply information in relation to a fact about which he was silent is Section 34. Section 35 is in relation to silence at the court. The defendant would be expected to take the stand. The defendant would be expected to subject himself to cross-examination. He, after all, is the accused. What happens if he chooses not to do that? After all, he has a right to silence from the beginning of the process to the end of the process, from the beginning of the criminal litigation process to the end of the criminal litigation process. He is not required to volunteer any information. However, Section 35 allows the judge to direct the jury to draw an adverse inference of guilt against the defendant where he chooses to remain silent at the trial. And side note, this also applies for partial silence. This came up in one of the past papers. It was an examinable point, and some students did it incorrectly. Because the defendant did take the stand, but he chose not to answer certain questions. So 35 applies in the absolute and it also applies in the partial. It applies where the defendant doesn't take the stand at all, and it also applies where he does take the stand, but he does not answer certain questions. Section 35 applies in the absolute and it also applies in the partial as well. Don't miss that partial point. In the problem type question, they may tell you that the defendant does take the stand, but he does not answer all the questions put to him. This is a partial application. Section 35 still applies in relation to the questions that he did not answer. The relevant case here is the case of R and Co-1. You are going to find the articulation of the direction in the case of R and Co-1, i.e., how should the judge go about issuing this direction to the jury? Is he able to say it in any way that he wants to, or is there a recommended way in which the direction should be articulated. You will get that information in the case of R and Co 1. You should also pay particular attention to section 35(1)(b). Section 35(1)(b) talks about circumstances where it is reasonable. Circumstances where it is reasonable for the court to not issue an adverse inference of guilt against the defendant where he remains silent at the trial. At section 35(1)(b), you would see them making reference to the on account of the defendant's mental or physical condition, it makes any evidence that he would give undesirable. For example, let us say that the defendant is only able to say on account of some medical condition, dog. He's literally sitting down going, dog, 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 dog. Where's your name? Dog, dog, dog. Where you living? Dog, dog, dog. You have any siblings? Dog, dog, dog. If the defendant is sitting down whole day, only saying dog, 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 does it make sense to put him on the stand? When you put him on the stand, what do you think he's going to say? What do you think he's going to say while he's being cross-examined? He's just going to say dog, 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 dog. Where were you on the night of the 15th? Dog, 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 dog. Do you own a firearm? Dog, 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 dog. Do you know the victim? Dog, dog, dog. It does not make sense. So, on account of that mental condition that he has, any evidence that he gives would be undesirable. That is not going to have any probative value. That is not going to assist the court in determining the outcome of the matter. So what happens? He will remain silent. He is not going to take the stand. But what do? Do you go on to direct the jury to draw an adverse inference of guilt against the defendant in this circumstance, noting that he has a mental condition which interferes with the quality of his evidence? Are you still going to tell the jury to draw an adverse inference of guilt? The answer is no. So, if section 35(1)(b) applies, the judge will not issue an adverse inference of guilt. The judge will not direct the jury to draw an adverse inference of guilt against the defendant. Because even if he took the stand on account of his mental condition, any evidence that he gives will be undesirable. When you are studying section 35, there are two examinable points. The articulation of the direction coming from the case of R and Co 1, and also 35(1)(b). Once you get past 35, you want to think about 36, section 36. Section 36 of the Act makes reference to the defendant being silent in relation to some substance, some object, or some mark. And this is usually at the time of his arrest. He has in his possession some substance or some object, or he has some mark on him. And the police ask him a question in relation to the substance, the object, or the mark. And in turn, the defendant says absolutely nothing. So For example, the police get a call. Someone just tried to rob a bar. The bar owner took a bottle and broke it on the face of the assailant, cutting him. The assailant ran out of the bar. While the police are driving to the bar, they see a man matching the description of the assailant running away from the bar. So they stop him. The police observe a fresh wound on the face of the suspect. They ask him, "Sir, you are bleeding from the face. Where did you get that mark from? Where did you get that cut from? Where did you get that wound from?" He says absolutely nothing. They go on to arrest him because they have reasonable suspicion you're matching the description of the suspect. So they arrest him and they take him to the station. Up to this point, he has said absolutely nothing. If you just fell down, let us say coincidentally, you are on the same street as the bar. Coincidentally, you are walking in the opposite direction. You are heading in the opposite direction from the bar. Let us say coincidentally, you trip over a stone and hit your face, and you have a fresh cut on your face. All of this is happening coincidentally. You are not the assailant. The police see you and stop you. What would you tell the police when they ask you, where did you get that scar from on your face? Where did you get that cut from on your face? Would you not tell them, "I literally just tripped and fell on my face. I grazed up all my hand, I grazed up all my leg. Look, I have cuts on my leg too." Would you not tell them that? Yeah, that would be the normal thing to do. You would volunteer that information. And that would alert the police maybe to the fact that you are not the suspect, because we are looking for someone who would have gotten that wound by virtue of a glass bottle being broken on his face, not someone who just fell down in the street and cut the face. You have white man all on your knee, white man all on your elbow. You would not at the bar. The police would ask you, "You now coming from the bar?" You say, "No, I'm not coming from the bar. I don't drink. I'm coming from by my mother's house. She lives 3 houses down from the bar." They're able to remove you from their mind as a suspect. Maybe they don't have reasonable suspicion to arrest you. But what changed the circumstances? You volunteered information. So Section 36 applies. Because at the time of arrest, in relation to some mark